Hello, my name is Greg Kampner. I'm the county attorney for Albemarle County, and this session is to discuss the new Proffer Law, which became effective July 1st, 2016. And for those of you on the CACs who are interested, that new Proffer Law is found in Virginia Code section 15.2-2303.4. The new Proffer Law changed the way in which localities can accept proffers from developers who are seeking to rezone their property. There's some things that CAC members should know about what the new Proffer Law does. The first key thing is that the new Proffer Law prohibits a locality from requesting, suggesting, or accepting what the General Assembly has called an unreasonable proffer, and we'll discuss what an unreasonable proffer is in just a moment. The other significant change of the new Proffer Law is that it limits the scope of the proffers that the locality can accept. So now localities can accept proffers only pertaining to transportation, schools, public safety, and parks and recreation. So some of the proffers that the county has frequently accepted in the past, such as proffered plans, proffers for affordable housing, phasing development, enhanced stormwater, and erosion and sediment control, and other types of proffers are no longer allowed. The next limitation on the new Proffer Law is that it applies only to residential rezonings. So what we are talking about today has nothing to do with commercial development, although it does apply to the residential portions of mixed-use developments. The last key thing to know about the new Proffer legislation is that it applies only to rezoning applications filed on or after July 1st, 2016. For those proffers that were accepted before that date, but the developer is seeking to amend those proffers, the old rules apply. The new Proffer Law imposes significant consequences on localities if they fail to follow the requirements of the new law. If a rezoning application is denied and the developer claims that the denial was based in part by the applicant's refusal to submit an unreasonable proffer, the developer can challenge that decision, and the burden of proof will be in favor of the applicant. And the remedy for the court in that kind of case is to order the locality to approve the rezoning if the developer is successful. Even if the locality approves the rezoning, the developer can nonetheless challenge an unreasonable proffer that the locality accepted. And in that case, the remedy is to have the unreasonable proffer stricken. So it's very important for the locality to be very diligent in examining the proffers to make sure that all of those that are accepted are in fact reasonable. The final consequence for localities is that the successful applicant is entitled to reasonable attorney's fees and costs. Now let's look at the meaning of unreasonable. And this is language that is pulled right out of the new Proffer Law. And we will look in more depth in following slides at the highlighted text, but the key elements of the what is and is not an unreasonable proffer. To be reasonable, the proffer must be specifically attributable to an impact. And then for proffers that are addressing impacts to offsite public facilities, including cash proffers, there are two key elements as you see in the two bullets. One is that the proffers can apply only to address public facility improvements that are in excess of existing public facility capacity. And the new development has to receive a direct and material benefit from the proffer. And we'll look at these in some following slides. Let's look at the requirement that a proffer address only specifically attributable impacts caused by the development. This new standard replaces the long-standing standard of reasonableness. The prior standard was that there had to be a reasonable nexus between the impact and the condition or the proffer, and that the extent of that condition or proffer had to be roughly proportional to the impact it was trying to address. The new standard requires that the proffer address a specifically attributable impact. Specifically is not defined in the new proffer law, but the common definition found in the dictionary is that specifically means with exactness and precision. And so that new standard requires a level of certitude that is greatly enhanced above what was previously required. It's a standard that may be difficult to achieve through various types of studies, at least for example, traffic studies. It may jeopardize the validity of proffers. It might provide any benefit to the public that lives outside of the development because the proffer is providing benefits beyond just impacts caused by the development. And it also prevents the county from relying on reasonable county-wide averages that were typically the foundation for the county's prior proffer policy. Now we're looking at the requirements for offsite proffers, and the first key requirement is that the proffers can address impacts on public facilities only in excess of existing capacity. And so the county needs to obviously assess its current capacity and then tailor the analysis and the proffer discussions to focus only on those impacts that are in excess of that capacity. And in the middle of this slide, you see an example where we look at how this new requirement would be applied, dealing with the example of an elementary school. One of the concerns that we've had, which is not addressed in the new legislation, is that capacity can change over time, and particularly for those types of public facilities where there may be lag time between, for example, the cash contribution and the actual construction of that public facility. It's possible that the developer could come in later to amend the proffer as the capacity needs have changed. The other key requirement for offsite proffers is that they must provide a direct and material benefit to the residential development. Unfortunately, there's no guidance as to how that benefit is to be measured. And as we previously have mentioned, there's often lag time between the payment of a cash proffer and when that public facility for which the cash was contributed is constructed. So we'll look at some strategies for members of CACs to deal with this new law. It's perfectly fine for the CAC to continue to receive information from the developer, but you may want to consider shifting the dialogue that you have with the developer to having that dialogue with county staff, particularly if you want to discuss proffers that might be recommended by the CAC. The second thing that members of the CAC can do is to consider alternative ways for the developer to commit to matters that are now beyond the scope of proffers. Many, if not most, of the rezoning applications these days are to rezone to a planned district. And planned districts provide some additional options to deal with impacts from a new development. The planned development district requires that an application plan be submitted, and in the neighborhood model development zoning district, the developer must also submit a code of development. And commitments can be shown on application plans and stated in codes of development for certain types of improvements, amenities, and other matters requested by the CACs or by the county that are beyond the scope of proffers under the new proffer law. A couple of additional strategies. One is that at the stage of the rezoning process, when the CAC is looking at a rezoning application, it's unlikely that the studies of the impacts have been completed. And so we recommend that CAC members should not suggest any proffers at that point. And we have a particular example on the slide. Avoid any kind of statement such as, I think you need to proffer X. However, it is appropriate to ask county staff or the developer whether any impacts have been identified and how the developer plans to address them. This slide shows some sample questions that CAC members may ask developers. This is not an exhaustive list, but it is just a starting point. Here are some final thoughts. First, understand that the new Proffer Law was neither opposed by every locality nor supported by every developer. And a couple of other things that we have not talked about yet. One is that the new law will require that the impacts of rezonings be evaluated on a case-by-case basis. That's one of the reasons why the board repealed the cash proffer policy in 2016. The final thought is that this will be a learn-as-you-go experience, not only for the county, but for every other locality in Virginia and all of the developers as to how this new law will be implemented in a fair and reasonable way. So expect that there may be further guidance provided to not only CACs, but also to community development staff and the decision makers for the county as we gain more experience with the new law. Thank you for your attention, and if you have any questions, and we certainly expect that you may have some questions, please feel free to contact Emily Kilroy and she will forward those to our office.